Hello, let us start the very interesting GS2 paper of UPSC Mains 2022. The first question is, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss the statement with the help of relevant case laws. They are asking, when the Supreme Court is involving in environmental issues that can lead to certain outcomes. What are they? Either Supreme Court will be issuing certain guidelines to prevent air pollution, water pollution kind of thing. Second, Supreme Court will be asking the central government or the state governments or the legislators, whether it is parliament or state legislators, to enact certain laws to protect the environment. Third, the Supreme Court can invoke certain articles or provisions in the constitution to protect the environment. So we will be seeing this through certain cases. First, you will be introducing this by saying that this is a significant milestone in the legal landscape of the country. What? This constitutionalization of environmental issues is a significant milestone. Why? It's a significant milestone because before this, either the government or legislature was taking steps, but now Supreme Court had stepped into their shoes. Okay, that reflected a proactive approach of Supreme Court to address these environmental challenges. This we can see through certain examples. For example, from in 1966 itself, Supreme Court had started addressing the air pollution in Delhi, which was caused by the industries and vehicular emissions. So, Supreme Court had began to regulate these industries through its judgments in the MC Mehta versus Union of India case of 1986. This set a precedent for the court to encourage the PILs or public interest litigations to maintain the ecological balance, which we can see in the Vellore Citizens Welfare Forum versus Union of India case 1996. In that, Supreme Court had devised an innovative concept called polluter pays principle. That means if some industries is causing ecological damage, let them compensate it through this polluter pays principle. Okay, this kind of approach, this proactive approach or this judicial activism had underscored the court's emphasis. This highlighted the court's emphasis on ecological balance through PIL petitions. This was just a beginning. It had made the Supreme Court to diversify its involvement in diverse environmental issues. For example, in 1996 itself, that means in the Vellore Citizen Welfare Forum versus Union of India case that happened in 1996, from where polluter pays principle came, say in the same year, Supreme Court had done something to preserve the forest and biodiversity from what? Activities like mining and logging. This was a case related to Wildlife Protection Act of 1972. The case is called Godavarman Tirulpad versus Union of India case of 1996. In this, Supreme Court had expanded or broadened the interpretation of Wildlife Protection Act of 1972, like by saying that if you want to protect this wildlife, you have to protect the like forest and biodiversity, right? It's a very logical argument by the Supreme Court. So this began the court's involvement to safeguard sensitive ecosystems. Okay, sensitive ecosystems like forest and biodiversity in this case. Now, sensitive ecosystems is not only this natural ecosystem, but it can be man-made ecosystems as well. That is the case where we deal with the management of Taj Mahal. The waste management issue of Taj Mahal was dealt in a case called Almitra H. Patel versus Union of India case, same year 1996. Okay, this is also a sensitive environment or specific region. So, like region-wise, like conservation started with this. So, Supreme Court recognized the Taj Mahal's international importance because it's a UNESCO World Heritage Site, right? So it led to like the formation of guidelines to protect this site. Now, this kind of involvement by the Supreme Court was like this is like if you see these things are happening in the 80s and 90s, right? So these 90s, the beginnings of 90s, slowly led to the expansion of horizon of environmental issues being connected with the life or fundamental rights of a person. Okay, this we talked about the general environment. Now, in the beginning of these 90s, in the case with the cases like Subhash Kumar versus State of Bihar case of 1991, court said that right to clean environment is a fundamental right under Article 21. I'm sorry, Article 21. So it emphasized the individual's right to have a wholesome life. It's not like we are eating and like getting some benefits from the government and living. No, it should be like a meaningful life. For that we need a clean environment. So this marked a pivotal moment in linking the environmental protection with fundamental rights. Before this, there was just like either forest protection or wildlife protection or air pollution addressing or like specific region-wise protection like Taj Mahal, etc. But now directly it invoked a constitutional provision under Article 21 that right to clean environment is a fundamental right. So from this case, the horizon started expanding even wider. If this is related to fundamental right which is linked with the clean environment, now court had like stepped into bigger issues like environmental impact assessment. Okay, in Virender Gaur versus State of Haryana case of 1995, the court highlighted the importance of environmental impact assessment for development projects. That means the development must be sustainable. For that, you have to maintain the ecological sustainability. Okay, so sustainable development must happen. So that led to the formulation of guidelines for environmental clearances. We know that Environmental Protection Act, under this we created this environmental impact assessment like regulations by the government because of the guidelines issued by the Supreme Court in Virender Gaur versus State of Haryana case in 1995. So that is one thing. Then, so when we started talking about sustainable development, we have to start talking about how it is related to climate change and like other global environmental concerns like emissions by the industries and all. So Supreme Court with these kind of directives, while it promoted the sustainable development through environmental impact assessment for development project clearances, etc., it was actually contributing to the initiatives for climate change related things. So here in the case of Indian Council for Enviro Legal Action versus Union of India case 1996, Indian Council for Environmental Legal Action, that is Enviro Legal Action versus Union of India case 1996, it again addressed the vehicular pollution of Delhi, but this time it was not considered as a simple domestic problem, but it recognized the air pollution of Delhi as a contributor to the climate change. We know that Delhi is infamous for being the top ranker in the world's most polluted cities. So it is definitely contributing to the climate change. So it is by this consideration of air pollution of Delhi as an international issue, the court's directives to curb this emission aligned with the international efforts in mitigating the global warming. So we can conclude by saying that this is definitely Supreme Court's proactive approach in addressing the environmental problems through its judgments indeed constitutionalized the environmental issues in India. That was the question. Then you can say that it not only influenced domestic policies but also has contributed to the broader global discourse on environmental conservation and sustainable development. Right, we talked about that. So we introduced, okay, this was a significant milestone in the country's legal landscape because Supreme Court started stepping into this kind of regulatory activities through its judicial activism. Okay, it began with 1986 air pollution issue in Delhi, like in which it regulated the industries and vehicular emissions, etc. So that was a precedent. With this, Supreme Court started encouraging the PALs for ecological balance, which could be seen in the Vellore Citizens Welfare Forum versus Union of India case of 1996, in which Supreme Court had devised the polluter pays principle. So let the polluters compensate for the ecological damage that they are causing. So this was just a beginning. Now Supreme Court had diversified the issues in which it is taking cases under its custody. That is, you can see in the case of preservation of forest and biodiversity to prevent the mining and illegal logging, etc., for protecting the wildlife. So it expanded the Wildlife Protection Act of 1972. It has given broader interpretation in the case of T.N. Godavarman Tirumulpada versus Union of India case. So with this, it started region-wise protection. Okay, so forest and biodiversity is also a region. Now there is another example for conservation of specific region. Here the conservation of forest and biodiversity, that was a broader natural region. Now region-wise conservation in the man-made ecosystem as well. Like in the case of Taj Mahal, the waste management in Taj Mahal, in and around Taj Mahal, was discussed in the case of Almitra H. Patel versus Union of India case of 1996, right? So it recognized the monument's cultural and environmental significance. So that led to the formation of guidelines to protect the Taj Mahal and its surroundings. So slowly, like when it like initially air pollution kind of thing, then PILs for for the broader ecological damage addressing, then specific region wise thing in this natural forest and ecosystem, forest biodiversity, then man-made specific regions. We talked about Taj Mahal. Then slowly we could see that these things are happening in the 80s and 90s. So in the 90s, slowly a new thing was developing, that is linking the clean environment as a fundamental right, which you can see that in like Supreme Court was expanding the horizon of things. That means Supreme Court had said that for an individual to have a wholesome life, clean environment is a fundamental right under Article 21. This was discussed in the case of Subhash Kumar versus State of Bihar, case 1991. So that is the beginning of 90s. So this started linking environmental protection with fundamental rights. So just imagine, government is coming with a development project in an area. Supreme Court in 1995, a case called Virendra Gaur versus State of Haryana case. So if this was like right to clean environment was like linking an individual's fundamental right, now for a community's fundamental right. Okay, it again expanded the horizon, right? That's why it started mandating environmental impact assessment for clearance of developmental projects. The court ruled that development must be balanced with the ecological sustainability. Okay, then for that you have to devise some guidelines for environmental clearances. We know that environmental impact assessment etc. came under the Environmental Protection Act of 1986 etc. So when we talk about development versus ecological sustainability, we are talking about sustainable development. So court had linked the sustainable development with the climate change and the international environmental concerns in the case of Indian Council for Enviro Legal Action versus Union of India case in 1996, which addressed the vehicular pollution in Delhi, but not just as a domestic problem but as a contributor to climate change. So court was indeed aligning the national efforts with the international efforts to mitigate the global warming. So you can say that it is definitely Supreme Court has definitely constitutionalized the environmental issues in India, but that was not only based on that has not only influenced the domestic policies but also the international discourse on environmental conservation. Thank you.